I want to welcome everyone to the Fourth Circuit this morning, particularly a group of outstanding lawyers. Good to have you here. We look forward to your arguments. The first case, Madam Clerk, why don't you call the cases for us?
Yes, sir. Devin James Maraville versus Kalolo Kijakazi. Mr. Paletta.
Mr. Paletta, good to have you.
Good morning, Your Honors. My name's David Paletta. I represent the appellant Devin Maraville. This is a mental impairment case. Mr. Maraville contends that he meets listings 12.04, 12.10, 12.15. The ALJ acknowledged Mr. Maraville has severe impairments, but ruled that his condition had improved sufficiently to enable him to work. In oral argument, I will address 3 points. That no recent medical hospitalizations does not mean improvement, that the ALJ failed to consider the entire record, and that the district court was overly deferential. Regarding no recent hospitalizations, to understand the appellant's argument, it is important to understand his medical history. Between the ages of 8 and 14, he was hospitalized 6 times for suicidal, homicidal, and psychotic behavior. Between the ages of 11 and 16, he was placed in multiple group homes for many months. And while hospitalized and while in group homes, he was abused and traumatized. So by the age of 17, he had been given 9 different psychiatric diagnoses: ADHD, Asperger's, bipolar disorder, mood disorder, pervasive developmental disorder, PTSD, schizoaffective disorder, and Tourette's syndrome. Now, I don't argue that he has all of these conditions today. Rather, the number of these diagnoses reveals the severity and the complexity of his mental illness. The ALJ found mental illness, but citing no recent hospitalization 4 times, deemed that he had gotten better, at least enough to work. This conclusion was wrong for 6 reasons. First, listing 12 has no requirement of recent hospitalizations. 2, the North Carolina statutory standard for...
Do you contend that that's all the district court was relying on? I mean, we're looking at substantial evidence, and strikes me that that's a piece of the story, but at least my reading of the ALJ's work was he didn't say it's only because he hasn't been recently hospitalized that I reached this decision. Isn't that fair?
I think that the ALJ certainly relied heavily on that, but we see this court as having several issues to review. And I'm about to address what the ALJ relied on.
Well, one of the things that you keep talking about, at least in your papers, is that there was no consideration of the turning point records.
Yes.
Is that an error? Were those medical records? And didn't they well precede the time in which he would be getting benefits?
His medical history is long, and those records were from the age of 16, and
Until?
They were during the age of 16.
They stopped then?
He did stop Turning Point at age 18.
Right.
But no, that is...
Turning Point's a group home? What is it?
Yeah. No, I don't think
Turning
that's right.
Point is a program for students with mental impairments. It's like a special school.
Special school for students,
With
young
mental-
people with mental impairments.
Yes.
And his mental impairments were those ones you listed there a moment ago, including Asperger's.
Yes, and others. And it has trained specialists.
Asperger's is related to autism. is it?
Correct.
I mean, you can assume, but I don't understand these medical terms.
So.
Matter of fact, I don't understand most of these statutory.
I think you can make that broad assumption for more than just one of us.
Okay. So Asperger's is now considered part of the autism spectrum disorder.
Yeah.
And if I may, I would like to respond to Judge Motz.
I think you should respond to Judge Motz, and I'm sorry to have interrupted. Absolutely, you should.
So what's very important, Your Honor, is that after Mr. Marivelle turned 18 in September of 2016, 8 months later, his grandmother and neighbor took him to see Dr. Burkholdt because he was sleeping 20 hours a day, he was binge eating, and his mother was going back to rehab. Mr. Marivelle told Dr. Burkholdt that he felt like he was going to die. Dr. Burkholdt sent him to psychiatrist Miller. This is April and May of 2017, after the claim was filed. He told Dr. Miller that he was depressed, that he was hopeless, and he was in constant pain. Dr. Miller, the psychiatrist, assessed him to be at chronic high risk for self-harm, suicide, and violence. This is after he turned 18, after he filed his claim. Yet the ALJ does not mention these records from Dr. Burkholdt and Dr. Miller that pulled together all of the records. So we're not just relying on the records prior to 18, we're relying on those records. Though the other point to address your question is, he dropped out of therapy at age 17. So there aren't many records after that. The reason he dropped out of therapy is because he was abused and traumatized by mental health professionals who were supposed to help him. And he testified he doesn't trust these individuals, and the treatment he received was the most humiliating that he received in his life. So rather than assuming medical improvement, which, by the way, when the judge wrote medical improvement, that means he used to be worse. She found he had gotten better. And rather than assume that it's because he wasn't hospitalized, a simpler explanation is that he had a history of abuse, he didn't trust mental health professionals, and he had learned it was better to suffer in silence than to seek treatment.
But when you say that, assume I even agreed with you. I mean, we review for substantial evidence, and so if there are two different inferences that we could draw, you want to say he doesn't want to be around mental health professionals. The ALJ reached the other conclusion. The question is substantial evidence, right? We're not doing it afresh, right?
I'm glad you asked that question, Your Honor. I am not arguing for this court to reweigh the evidence, but the ALJ found...
But that's what it sounded like when you're like, oh, there's this evidence, he doesn't go back. I want you to infer from that he doesn't, he's afraid or traumatized by mental health professionals. Somebody else the ALJ drew a different conclusion from that. I'm not sure which of those inferences is better, right? I certainly understand your argument on the point, but it seems like to me that's the weighing of the evidence. The inference to be drawn from the lack of hospitalization. There are two plausible reasons that you've given, right? The ALJ chose one. What are we doing?
I'm glad you asked that question, Your Honor, because we are not asking for a reweighing of the evidence. And also, we acknowledge the burden of proof is on Mr. Marivelle at
So what are you asking for? You don't want us to reweigh the evidence. What do you want?
4 issues. 1, because the ALJ found mental illness, found 4 severe impairments, and found medical improvement, the issues this case raises are, did the ALJ consider the entire record? We submit no. I'm prepared to explain why. 2, did the ALJ add a requirement to listing 12 that is not in listing 12, and that requirement being recent hospitalizations? Did the ALJ do a function-by-function review in her RFC? That's required by the Mascio case in SSR 86-8P. There is no function-by-function review of mental limitations. And lastly, was the bridge that the ALJ built logical. And that's for you to consider. Those are legitimate appellate issues. Did they consider the entire evidence? Did they follow the rules? And those centrally are the issues of this case.
Well, does the ALJ have to expressly consider every piece of evidence? Is that your position?
No,
Well,
there's no per se
I'm trying to figure it out. Help me.
Sure. There's no per se rule. However, as the court said in Thomas, there is no per se rule, but the ALJ cannot regard tremendous evidence to the contrary. For example, the turning point records are relevant. The turning point records address all of the 12B criteria. They cannot be ignored. And 3 sentences in the decision address the turning point records. The ALJ spent more time on a one-time...
Only 3? That's the problem is the ALJ only spent 3 sentences on those records?
Well,
I mean, doesn't that give us some indication that he considered them?
well, there's a difference between, this is for your honors to decide, there's a difference between mentioning evidence and discussing evidence. And the line of cases from Radford, Mascio, and Monroe, what happened in all of those cases is the ALJ did not adequately explain the decision so that this court could do a meaningful review. And so our argument is there wasn't an adequate explanation of how, for example, Thomas requires evidence, a logical explanation, and conclusions. The logical explanation is what is missing here. She mentions evidence. In fact, it's the new technique of ALJs. They just go down the exhibit list and they mention it all. But here, for this court to review, there must be a discussion of the logic. And so
Well, if you look at step 3, which you would say is deficient, right?
yes.
You come to a conclusion, but you don't give the rationale for it. So there is more rationale in the step 4 discussion. Are we not allowed to consider that when we look at step 3?
Well, the opposing counsel says the answer is yes. And
Well, I'm asking you.
and relies on the Keene case. That case was not published and is not binding. The Radford case is on point. Radford was a step 3 case. And what the Radford court said was that the ALJ must, this is specifically in Radford, it's on point, the ALJ must explain their decision sufficiently for there to be meaningful review.
But I'm not sure that meets exactly my question. So if we should find that step 4 did explain the conclusions that are reached in step 3, do we avoid step 4 and say, no, you have to have all this stuff in step 3?
Well, the case law does not support that ruling because the case...
So the case law says you cannot look at the step 4, you have to look at only this rationale given in step 3.
No.
Is that it? I'm just trying to get the answer.
There is no per se rule. So it doesn't say you cannot do this or you cannot do that.
Okay.
And we're not arguing per se rule. What it says, most of the cases out there are step 4 and 5 cases. There aren't many step 3 cases. This is primarily a step 3 case. Well, Radford was a step 3 case. It is directly on point. The argument made by counsel in Radford was you look at the whole decision. That was also the argument made by counsel in the Woods case. Woods argued, the commissioner argued, look at the whole decision. And this court said in Woods, no. You look, the ALJ must identify the evidence relied upon and then must build an accurate and logical bridge. So the question for this court is, did the ALJ build an accurate and logical bridge from the evidence to her conclusions? If you find that, then you rule for the commissioner. We submit that that logical bridge is missing.
So you want us to remand it to the
We are seeking-
ALJ for more work?
Yes, we are seeking a remand, and the reason...
You're not asking us to award benefits or anything?
No, Your Honor, I don't think the facts
You just
support
want to
that.
say that they didn't do it right
Correct,
this time around, and they need to do more.
correct. They must explain the reasoning. They must, I don't want to,
So you would say we need to remand it to the district court and tell the district court it needs to be remanded to the commissioner and the ALJ for more work.
that is correct, and that is.
Right under the procedures and consider the things, build this logical bridge if they're going to, or give him benefits.
That is the relief sought.
And if he gets benefits, he's not a child anymore. What's the effect of it?
Well, he filed two claims. One is a supplemental SSI claim. That's basically a welfare type of disability for poor people. That's claim one. The second claim is under Social Security, you can file benefits if you become disabled prior to the age of 22, if your parent is deceased.
And he's not under 22 anymore.
He was 20 at the time of the hearing. He's about 22 now. So he must prove disability prior to the age of 22. And that's why the records from Dr. Burkholt and Dr.
Well, if he proves he's disabled prior to 22, if he get the child benefits,
Then he draws disability under his deceased father's work record or his disabled mother's work
he
record.
gets the benefits until he's 22, or do you get him the rest of his life?
He gets them until the point he becomes not disabled.
He gets them as long as he continues to be disabled.
Correct. But this program is only available to adult children after he turns 22. It's no longer available.
I'm just trying to understand the basics of all this. Some of it sounds like it's greed.
So a couple main points. One is that the records from April and May of 2017 are very important because they're after he turned 18. The psychiatrist found severe mental health symptoms. They indicate that the severity of the symptoms that's shown in the prior records is ongoing, and the ALJ did not mention these records. We would submit that that's error in and of itself because the case law says the ALJ must explain contrary evidence. These are the most important records in the file, and they are not mentioned anywhere in the decision.
I know you're out of time, but on your reply, I don't need it now. Can you, the Burkholt and Miller records, when I see your argument about the ALJ failed to consider the entire record, I don't see any mention of those records. And so when you come back up on reply, I'd love for you to show me where you've made that argument.
Sure.
Thank you.
Mr. Summers? You represent the commissioner?
Yes, Your Honor, thank you. Good morning. May it please the court.
Good to have you with us.
Thank you.
And you're a special assistant United States attorney?
Yes,
That means you actually work for the Social Security Administration.
Yes,
They designate you as a special assistant for purpose of handling this case.
yes. The Middle District of North Carolina appointed me as a special assistant United States attorney to handle this case.
Good to have you here.
Thank you very much.
Yep.
I'm arguing on behalf of the acting commissioner of Social Security. This case is not about minimizing Mr. Maravel's history or his mental health impairments. Because he applied for disability benefits after he turned 18 in September 2016, what Mr. Maravel's case was about before the ALJ was whether he had functional limitations that prevented him from entering the workforce as an adult. Zeroing in on that issue, the ALJ acknowledged Mr. Maravel's history, detailing the intensive mental health treatment he received as an adolescent and a younger teenager, and recognizing, quote, that he experienced significant traumatic events during childhood, end quote.
What duty does the ALJ have to explain his decisions?
So the ALJ's obligation in explaining her findings in this case is to present her rationale in a statement of the case that shows how she got to her conclusions based on the evidence.
And where does she do that?
She does that in two places. So Focusing on the arguments that are at issue here, which are the Step 3 finding and then the residual functional capacity finding, the RFC finding. So at 5 to 6, when doing the Step 3 analysis, where the ALJ finds that Mr. Marivelle does not have a marked level of limitation in any of the
I'm
four.
sorry, you're looking at 5 to 6 of what?
Oh, sorry.
Number
Yeah,
of-
so I'm using the pagination, which I think tracks with the joint appendix, or it's page 19 of the transcript.
Got it.
You have the transcript site. So on that page, we have the ALJ's making those findings and provides sort of a general overview of the evidence. There's really three main lines of evidence that the ALJ is relying on here. She's relying on the treatment records, which show that as an adult, Mr. Marivelle was in a much better place, where where we could expect him to enter the workforce. Unlike, and this addresses one of counsel's points, unlike when he was younger, when he was presented with situational stressors as an adult, he doesn't require the same intensive inpatient treatment that he required when he was younger. And so the ALJ on that page is citing to the fact that, for example, that he seems to respond well to medications. And that actually comes directly from the psychiatric records that counsel had cited to in May 2017. In May 2017, counsel reports to Dr. Miller, that he thinks his medications are working well for him, and he was feeling more hopeful. And that's after a period of significant situational stressors related to his mother's mental health issues and her sobriety. And he comes out of that saying that his medications are working well and he doesn't require the same kind of inpatient treatment that he required previously. So the ALJ is citing to that there. And the ALJ is also citing to evidence there regarding, and also on that point, I would point out that after May 2017, the treatment modality that he's receiving is he goes to his primary care doctor, he receives a medication regimen, and he's generally reporting, that he's doing pretty good. So then we have, that treatment, that line of evidence, that treatment records. You can see that the ALJ is considering that at page 5 to 6 when she's citing to that evidence. And then also on that page, she's citing
I
to.
guess, maybe I'm expecting too much, and maybe you look at a lot of these. She states these facts. I don't see her making, balancing one thing against the other and saying X, 1, 2, and therefore 3. I just see 1 and 2 put down.
Well,
Do you understand what I'm saying?
Yes. So she's saying here that she's rating Mr. Marivelle on the 5-point scale in terms of in the various categories at the various levels, and then she's providing an overview of the evidence that she's considered when she made that assessment. And so what she's doing there is explaining why the overall rating hits no or moderate or mild in those levels, and that's relying on that evidence there. And that's made in the context of the ALJ then going on, as Your Honor had mentioned, before the Step 4 assessment, when making the RFC finding, the ALJ goes through the evidence in greater detail and ends with a summary on page 24 to 25, where the ALJ is sort of explaining her overall view of the evidence, which is that as an adult, Mr. Marivelle's in a better place. He can handle this range of work that it addresses his limitations. It's not that the ALJ found that Mr. Marivelle could perform any type of work. Mr. Marivelle's has 109 IQ, he has average cognitive functioning, and the ALJ recognizes that he could perform work involving complex tasks, but owing to the fact that he has these mental health symptoms and they're still there, they're present. And
He worked in his life, he worked for a week one time.
yes, he attempted to work the counter at Five Guys,
5 guys for a week.
a hamburger restaurant.
Is that the extent of his work history?
I believe so, yes, that is the extent of his work history. But his testimony as to,
22 years old.
at the time of the ALJ's decision, he's around 20. And so he testifies that the reason why he struggled at Five Guys is that there was the constant customer interaction and having to keep up with taking customers, relaying the orders to his coworkers. That was the problem. And that's not a feature of what the ALJ finds him capable of. The ALJ limits him to work where there's no contact with the public and only occasional interaction with coworkers. The jobs that are eventually cited at step 5 are housekeeper, routing clerk, marker, that's like a price marker at a retail store. A router is somebody who sorts boxes at a mailing facility. And a housekeeper is a housekeeper. The ALJ is keyed in on the type of limitations that Mr. Marivelle had and is addressing that through her findings. And so those 3 lines of evidence that I was talking about, the first was the treatment records, where we went through, and as I pointed out, I think those treatment records from April and May of 2017 support the ALJ's analysis. And the ALJ discusses them on 20 pages.
The ALJ never mentions the Turning Point records, right?
No, the ALJ does mention the Turning Point records, does discuss them at page, I believe.
They're the fullest set of records. Yes? They're the fullest set of records. There is a long period and very detailed and helpful to the claimant records from the Turning Point people.
Yes.
Right?
Yes.
And that certainly don't get that attention from the ALJ.
Well, I mean, so the ALJ gives them attention that those records are certainly relevant. They tell the story. They're the preamble, so to speak, of how we're going to look at Mr. Marivelle as an adult.
And where does the ALJ say that?
I mean, that's what the ALJ's decision conveys. I mean, to address sort of the general duties of an ALJ, I think the standard is that an ALJ's discussion needs to provide enough analysis for the rationale to be reasonably discernible. So we need to be able to understand, as we read the whole decision, whether or not the ALJ considered the evidence and made a reasonable conclusion, whether or not we can perform substantial evidence review. So what were the reasons that the ALJ, if we know what the reasons the ALJ found, then we can look through the record and decide and see whether or not the ALJ was relying on evidence that a reasonable mind might accept as adequate, which is what the substantial evidence standard is.
So another way of asking that is, so the Turning Point records, I understand it's like 123 days of treatment. So he's only there for a relatively short period of time. And it's, the conclusions in those records are consistent with what the ALJ described as this individual's problems when he was, 14, 15, 16.
Yes,
is that is that what I'm
Yes.
just trying to understand precisely what you're saying.
So
this was this little slice of information. It's consistent with what the ALJ described, and that's how we discern that there's nothing that wasn't properly considered.
Yes, we can discern that the ALJ looked at those records, considered them, and then when we see that the ALJ is talking about how, as an adult, Mr. Marivelle is in a different place, when the ALJ is focusing on the evidence regarding him responding well to medications, regarding his reports about his activities. And Mr. Marivelle testified to playing involved computer games and studying history, and those weren't fleeting activities. He reported doing those for hours at a time during the day. And he also, in terms of social functioning, which was an issue for him, he did report difficulty making friends, but also he had friends. He reported social gatherings as one of his hobbies. He went to an outing the day before his disability hearing where he went and visited friends they had not seen in a while. And so that line of evidence is also something the ALJ marshals here to lead to this conclusion. And then
Can you respond, at least as I understood it, and maybe I misunderstood it, which is entirely fair. Your colleague suggested that the Burkholt and Miller records were not mentioned by the ALJ. Can you respond to that argument?
They're mentioned by the ALJ. The ALJ cites to the UNC healthcare record. He doesn't identify the doctors by name, but he cites the UNC healthcare records from May 2017, Exhibit 6F, on page 24 of the decision. So the ALJ is considering that.
And that is the Burkholt and Miller.
Yeah, there's the Burkholt. Burkholt is Mr. Marivelle's primary care provider, and in April of 2017, she sends him to because he's having these situational stressors and he's struggling. And that's when he reports, for example, 20 hours of sleeping. And so she sends him to Dr. Miller. Dr. Miller examines, sees him twice, examines him, and notably those mental status examinations suggest that he's able to fully attend and concentrate. He's not exhibiting any concerning behaviors. They're fairly benign. And then after that, we have just continued treatment with Dr. Bergdahl. He doesn't go back to Dr. Miller again after that. And also in terms of the sleeping, that 20-hour sleeping complaint there, that's not pervasive throughout the record after, May 2017. In 2018, he says his sleep quality is okay. That's at 1495 of the record. He's sleeping without disruption for about 10 hours. Later that year, that's at 1501. And in fact, Dr. Bergdold actually takes away, or actually titrates him down on his sleep aid, clonidine, in 2018.
She does what?
Titrates it down, so she lowers the dosage and eventually takes that medication off because he doesn't need it.
So I think that you are pretty successfully demonstrating, at least to me, that there is evidence in this record to support what the ALJ did. And what I'm trying to figure out is if the ALJ has given us enough explanation, because I think that that's the essential argument that your colleague on the other side is making. Supporting your case is it seems like this is an exercise in futility if we would send this back if we thought there was sufficient evidence in the record. If the explanation met at least a minimum bar. But as I read the case law, if it doesn't, then we do have to send it back, even though it may be an exercise in futility. Is that correct?
I wouldn't say that. I mean,
I think the case law is pretty clear that the ALJ has to give a reasoned explanation of the conclusions that he or she reaches so that we can understand it.
Yes, I would agree with that. I would say that the ALJ if the ALJ doesn't provide a rationale that is reasonably discernible, then that would inhibit the ability to perform the substantial evidence review. But here we have that, and the third line of evidence that I haven't gotten to yet is the expert evidence here. And I think that's very significant here is that there's no medical opinion proposing that Mr. Marivel is markedly limited, or that he has any greater limitations than assessed by the ALJ. And the ALJ gives great weight to Dr. Knowles, who's a highly qualified expert in disability adjudication. And Dr. Knowles looks at his treatment records through September of 2017, including the Bergdorf and Miller records that we just discussed. And Dr. Knowles assesses that he has a moderate limitation, no more than a moderate limitation in any of the relevant categories, and that he can handle a range of simple work. And the ALJ gives great weight to that assessment.
So there are a bunch of experts, right?
There's three, yes.
Yes, and one of the experts...
Well, three on mental, sorry, excuse me.
I don't understand what you just said. I thought there were more than three, but in any event, I thought that one or two of the experts never saw him, just studied his records. Not true?
The Dr. Knowles, Dr. Saad and Dr. Knowles, they are the state agency consultants who they review the record.
Right, but they never examined him.
No, they never examined him, but they review his medical records.
And a person who did examine him, they relied on the records created by that person, right?
Yes.
And didn't the ALJ find that that person was not credible?
They didn't find that person was not credible. They found that the limitations were vague in the sense that they didn't give a specific...
She rejected. The person who saw him's record, she rejected.
Rejected.
All right, and is the ALJ a male or a female?
She's a she. It's a
She,
she.
I thought it was. I started calling her, him. Okay.
No, the ALJ does not... the ALJ doesn't reject the consultative examiners, whose name is, for some reason, escaping me, does not reject her report. What the ALJ explains is that it was vague in the degree of limitations, but it's also largely consistent with her findings. So the ALJ finds at 25, when addressing, she gives partial weight to the consultative examination in Exhibit 3F. And that consultative examiner is the one who assesses 109 IQ, is the one who assesses that he's able to handle simple tasks and attend to simple instructions. And she assesses social awkwardness and some difficulty in terms of interacting with others, but doesn't go...
Dr. Derringer.
So Dr. Derringer is the physical. So that's why I said 3 instead of 4. I see I'm out of time. I don't want... Okay. Dr. Derringer is the physical examiner, and
so he is. That's what I was trying to say. Maybe,
and so there's no challenge.
I haven't, but so he's the person that actually did see the man, and the other people just read records. Well, and she does. I mean, just that seems odd.
So the reason why the ALJ doesn't give that specific weight to there is because of the lack of a specific functional assessment, which is like the most helpful thing. But the ALJ does consider that exam. And I'll point out that that's not that exam. It relates to his physical functioning. And as counsel indicated, this case is at the appellate level now is about his mental functioning, and not, there's no argument here that the ALJ was made any errors in terms of assessing a light work finding in terms of his physical capabilities.
Excuse me,
Should we adjourn a bit?
would you answer questions as long as you get them? On the time question.
Yeah, sorry. So if I could just sum up, I would just say that the ALJ here did provide a valid explanation. There's enough discussion in this where the ALJ is citing to the fact that he's responding well to medications and his treatment records as an adult, his activities that he was performing as an adult, and then Dr. Knowles' assessment and the other medical opinions do support the ALJ's assessment. So for that reason, we'd ask that we'd affirm the ALJ's decision.
Mr. Pauletta?
Responding to Judge Richardson's question, I argue at 3 places in my brief that Dr. Burkholt and Miller records were not considered. The first place is the first full paragraph at page 5. The second place is the first paragraph on page 32. And the third place,
I'm sorry, let me go back to, yeah, page 5 is the fact section, right?
yes.
And so tell me, what's the argument that you're making that they didn't consider the record? I mean, I'm happy to just go back and look at it, but when I just skim what you're saying there, that doesn't include anything to me that the ALJ failed to consider Bergdolt's records, right? It describes Bergdolt's records, but it doesn't say the ALJ made an error.
The ALJ never mentions Dr. Burkholt records from April of 2017.
Show me where you say that in your brief, is what I'm trying to get. I mean, that's totally fine. When you said it in argument, that was not an issue that I was familiar with. And it may well be that I just missed it. But what I'm trying to find is, where do you say that in your brief? Not where do you talk about Dr. Bergdolt. Do you see what I'm saying? Because when you make the argument on page 20 and 21, the ALJ failed to consider the entire record.
Yes.
You talked about the turning point records, and Judge Mott's asked you about those. But then when you stood up to argue, you said, no, there are these other records that they failed to consider.
Page 39,
Okay.
top, I say, and this I'm talking about the district court error because I needed to address that. And I say, first, I've already mentioned these records twice, and here I say, however, page 39, the district court does not address the failure of the ALJ to discuss UNC health records that document Mr. Marivelle experienced very severe symptoms.
And your argument is that sentence preserves the separate argument that the ALJ made the error that you're sort of using as the premise.
Yes.
So what you're saying is the district court erred, and that, in your view, preserves the argument that the ALJ erred.
Well, I've always argued that ALJ did not consider all of the evidence. Or didn't consider the entire record. So with regard...
And I don't want to belabor this, but when you do that, that's fine. You make that argument very clearly at page 20 of your brief. But the only thing you cite to, right, are these, the TEACH report and the turning point records.
Yes, and on page 39, I say the district court let the judge not discuss that. And so I feel I made that argument, but Your Honor's the judge and I'm not. The opposing counsel cites statements by Mr. Marivelle, such as he has friends and he had seen them shortly, indicating he's not severely disabled today. ALJ did the same thing. In Mascio, the ALJ did the same thing. And this court ruled that when the ALJ cites statements by the claimant, the ALJ must explain how she decided what to believe and what not to believe. And so in this case, the ALJ cited some statements, disregarded all of the statements indicating severe impairment. For example, within minutes after Mr. Marivelle testified that he socialized somewhat, he discussed the voices he hears in his head that say horrible things, so horrible he would not discuss them, and that are totally distracting and upsetting. That wasn't mentioned by the ALJ. So the ALJ looked at one part of the record and did not explain how she decided what to believe and what not to believe.
Well, I think the latter of what you said is true, or may be true, but I'm not sure that you're right about what you said at the beginning, because if you look at page 24, she says, after careful consideration of the evidence, the undersigned finds that the claimant's medically determinative impairments could reasonably be expected to cause the alleged symptoms. However, the claimant's statements concerning the intensity, persistence, and limiting effects of those symptoms are not entirely consistent with the medical evidence and other evidence in the record.
Yes, so
I
that
think she is explaining what she
that
is
her
crediting.
that is her conclusion. And what I have argued is she leaves out the logical explanation that connects the evidence to that conclusion. Further, I don't want to, since I got so many questions first time around, I don't want to leave out, there's no function-by-function review of the mental limitations. Mascio et al. Require the ALJ to do a function-by-function review first. The ALJ did not do that. She did the residual functional capacity expression first. That's an error of law. I cited my brief. That's another. So we don't want the court to reweigh the evidence, but we want the court to hold the ALJ.
Did you make this argument in your brief?
Yes.
Function by function review?
There's no, the function-by-function review came after the expression of the RFC in violation of Mascio. I think I'm out of time, but any further questions?
We appreciate very much, Mr. Paletta,
Thank you for your consideration.
work in this case, and you as well, Mr. Summers. We thank both of you.
Yes, sir.
Good to have you with us, Mr. Hawkins.
Forgive me while I pull out our record.
Will you take your time? When you're ready.
Good morning.
Good to have you with us.
Thank you. Judge King, members of the panel, may it please the court. I'm Richard Hawkins. I'm here this morning on behalf of the plaintiff, appellant, Eva Palmer, who's also the cross appellee. We begin this morning with Ms. Palmer's age discrimination claim. And Your Honors, this is a case that should have gone to trial. This is a case where I should have been allowed to stand in front of a jury and say, ladies and gentlemen, Eva Palmer, a 32-year veteran of Liberty University, who was terminated at age 79, just 1 year after being promoted to the highest position available to her at the university, was a victim of unlawful age discrimination.
What is your best evidence that Liberty's legitimate, non-discriminatory reason for discharging her, for not renewing her, is pretextual? Best evidence that it's pretextual.
There's three pieces that go together, but I think the best is the promotion itself. And it's the promotion that is contextually connected and intertwined with guidelines that Liberty itself set forth that required excellence in teaching. And Liberty, of course, testified in its deposition that a promotion is evidence of excellence in teaching, and if there had not been excellence in teaching, Ms. Palmer would never have been promoted. And the reason that the promotion is the best evidence is because in all of the years prior to that promotion, the criticism that was the justification for the termination or the non-renewal, the quote, legitimate expectations or the legitimate non-discriminatory reason was her failure to meet digital literacy criteria. And these were criticisms that had been raised every year.
So it's your position that she has now met those requirements, and that's why she was regarded as that their things are pretextual, that their reason for not renewing her is pretextual?
I'd be a little bit more nuanced.
The record didn't read to me as if she had met those requirements.
I take a more nuanced view of that because what I'm saying is that because in order to show a reason is pretextual, we can also show that it is illegitimate and that it is not genuine. And when somebody has been told year after year after year that you're not meeting this criteria, and then they get promoted based on criteria that include these prior criticisms, then to then terminate that person the year later based on those criteria is not legitimate. That shows pretext. That shows that it was not the
Help me
real
understand
reason.
that. Say that one more time. Your argument is that it can be the true reason that, in fact, she could not do digital art, she was unable to teach it, and that if we had the truth serum, we could talk to the dean, and the dean would say that I fired her for that reason. And that can be all true in your view, and you still prevail because you think digital arts is illegitimate and unnecessary at Liberty.
No. I'm not.
Help me understand what because it seemed like what you were saying is that can be true, but I'm going to decide that digital arts is illegitimate and unnecessary.
No. The illegitimacy is the explanation itself. It is one thing to say you don't have digital art skills, and we will concede that she did not attain certain levels of digital literacy. But that is not a legitimate basis on which to non-renew her. And the proffering of that reason.
Can you tell me what you mean by legitimate in that sense? Because legitimate seems to me true but not valuable, right? What you're trying to say is true but not valuable, right? So that is the reason that she was fired, but they shouldn't be able to do that. And that goes back to this suggestion that you're saying, well, they just don't really matter.
Well, it's not that they shouldn't be able to do that, but they shouldn't be able to use that reason as a mask to cover age discrimination. And we say that it's a mask, that it is not the legitimate reason. It's not the actual motivation for why they terminated her or why they non-renewed her. Because if you look at all of the preceding years, she had been performing at a level that was allegedly deficient, and then she gets promoted, which wipes the slate clean, which means that can no longer be the legitimate basis. To say that makes it illegitimate. It is factually correct in the sense that they say you needed to meet this requirement, you didn't meet this requirement. But it is not a legitimate basis upon which to base a non-renewal when there is so much other evidence, which we've identified here with regard to the criteria for the promotion, that
So as I
undermines
understand,
that.
you're using the word legitimate to mean true.
Yes. But true as in motivation, not true as in a fact point of, I say you need to wear red, and you don't wear red, so you didn't wear red. And then I say, well, you're now terminated because you didn't wear red. But what is in my mind is that you're 79 years old.
Well, what if subsequently you hire people that all wear red? Doesn't that give you some suggestion that the red requirement was, in fact?
Except they didn't. Chris Phillips, who is the professor, is the person who ended up not doing any of these digital literacy
The
proceedings.
new people that were hired couldn't do digital?
They could, but the point that was the justification for this requirement being of such importance and of such a critical metric to require termination or require non-renewal was that it was, they had a shifting dynamic in the classroom. They had motivating students were now more interested in these particular classes.
And you doubt that?
I do. I do. And the doubting comes from the post semesters. You look at the record, it's 1413, 1419, 1418, 1416. Those are the classes that were taught. And Chris Phillips had these alleged crossover skills. It's not just that you had the skills. It's that they were important for crossover teaching. But Professor Phillips didn't do any crossover teaching. And that undermines the legitimacy, the truth, of whether or not that's a valid justification for her non-renewal. So again, it's the promotion that's the starting piece, but then you look at the subsequent pieces of what happened after the fact. And they did not hire people who were red in that particular context. Your Honor, I've tried to think about what could I say this morning that you haven't already read in the briefs. There's not a whole lot that can be said, except that I would emphasize three things. And that is Sempowich, Sempowich, and Sempowich, because that case has almost precisely the type of pre-termination negative evidence and pre-termination positive evidence that gets balanced and that undermines the employer's legitimate justification or alleged legitimate justification. And this court said, and the case was decided literally 5 days or 9 days before Judge Moon issued his decision. Obviously, if we'd had it front and center, we would have raised it immediately. But we think that the analysis in Sempowich calls into question the legitimacy of an employer's actions. And of course, in that case, the sales representative or the sales team leader had missed all of these sales goals and had conceded that she had missed the sales goals. But they had rated her well, and they had rated her in a way that made her think that she was doing well. And so against the balance, and they'd given her a raise. And then they said, well, you're not doing well, you need to be transferred. They had also told her, or the evidence in that case was also that they had never told her that if she failed in her sales quotas or in her sales expectations, that she would be reassigned. That's the same evidence we have here. And this court said that if an employer genuinely believed that the employee was failing on certain metrics that it believed were critical, then it shouldn't have all these other pieces of positive evidence. It shouldn't have given her a raise. It shouldn't have given her positive ratings. And the same is true here. If Liberty had truly believed that a lack of digital literacy skills or crossover skills was a genuine basis for non-renewal, then it never should have promoted her in the first place, and it never should have given her an almost $30,000 raise, and it never should have rated her meets expectations, again, which calls into question the legitimacy of the criteria, on digital literacy the year it told her that she was not meeting those expectations. Those are the counterbalancing pieces of evidence that a jury is required to consider. And we submit that both the pretext question and the issue of legitimate expectations cannot be decided on this record as a matter of law. And I invite the court to look not only at the Sempowich opinion, of course, from this court, but the district court's opinion in that case was some 23 pages at least, and it is chock full of details. It is robust in the factual information provided by the employer in that case, and it looks almost identical to what we have here. And that evidence wasn't good enough to be ruling as a matter of law. And that's our position here, that you cannot rule as a matter of law on those particular pieces. We've raised other errors as well. We believe that there is direct evidence of discrimination. The comments from Dean Hayes and the selection of retirement by Chair Smith.
Well, I don't think you actually, I understand what you're saying about Semowich, but the facts were very different. Very different.
And I know Your Honor was the author of that decision. But the facts were different in certain respects, but in the points that I'm trying to raise with the court, I do believe that they
Well,
are sufficiently similar.
The employer had rated her very high.
Correct.
Higher than other employers. I don't see any other employees. I don't see any evidence of that in this record. It repeatedly gave her awards, including one for sustained excellence, 3 weeks before it told her that it would reassign her position.
Correct.
I don't see any evidence of that in this record. Told her that he would give her a salary raise 3 weeks before it told her it would reassign her position, and gave her a discretionary equity grant 12 days before it told her that it was going to reassign her.
Correct.
There's no evidence like any of that in this
Well,
record.
the issue to that is timing, but you look at the timing we have
No,
here.
it's also additional approval,
Well,
even monetary approval.
but look at the approval we have here. In the fall of 2016, Palmer is promoted. She is now deemed full professor. They celebrate her in January of 2017. This is less than a year before they let her go. In June, she signs the new contract. That's her $30,000 raise. And this is less than 4 months before they let her
Is there
go.
any discussion of giving her awards that make her superior to other people? No, there's just not. The records are just, I understand why you're relying on it, but the cases are very different. I mean, sometimes you can recover on a cause of action. It's the same cause of action, but you can't recover on it under other facts. I mean, that's just life.
I totally agree, Your Honor.
You know?
But what I will say, though, and this is a comparative point that I do think is worth emphasis, is that the promotion is the sine qua non of what's going on here. It is evidence of excellence in teaching. So no, they didn't compare her to others per se, but they gave her the highest possible rank available at the university. They could not go any higher. They couldn't award her anything more in terms of her rank, and they did it less than a year before they decided they couldn't have her anymore. And it's our position that that is, with the other evidence that we have
And
here.
I'm misunderstanding the record. I thought that the discussion when they, all along, was that she had to get this digital stuff under the belt, and she had to be able to teach it. And when they gave her, whatever it is you were talking about, the promotion or they said that then too. And that was the agreement, and she never did it.
No, but they gave her the promotion anyway. And the point is,
But
you
the
shouldn't
hope
give...
was,
No, I don't believe it's the issue of hope. That is where I think the analysis goes astray, Your Honor.
Okay.
I think they say you need to do this, and then the question is what you've done sufficient? Not is it, over the top? Is it?
well, who determines that, the employee or the employer?
The employer, and they did. They rated her as meets expectations, and then they said she is promoted, which means that she satisfies their expectations, and that covers everything, including the digital literacy. So that's our position. I see that I am out. I will reserve. Thank you.
Thank you very much, sir. Mr. Tower?
Thank you, Your Honor. My name's King Tower, and I'm here with Leah Stiegler from my firm and David Corey, General Counsel. Your Honors, we're here today to discuss two issues. We cross-appealed on the ministerial exception issue in this case, but first I'll address the Age Discrimination and Employment Act issue. And just to refresh your recollection about the posture procedurally, Judge Moon was presented with cross motions for summary judgment first on the ministerial exception issue, whether Ms. Palmer should be a minister under the Supreme Court precedents. He denied Liberty's motion, granted Ms. Palmer's motion for summary judgment, so the case continued, and then we moved for summary judgment on the merits of the ADEA case, and he granted that. Your Honors, of course, our position is that he granted...
Judge Moon conduct an oral argument with you all?
A virtual oral argument, yes, sir. And in that matter, we presented then, as we do now, a case
You
with.
discussed both of these issues.
We did these in serial, although they were very close in time. The summary judgment motions, cross motions were argued first on one occasion, and then on a separate occasion, we came back on the merits.
Okay.
And
Sorry to cut you off, but we got a handful of things to run through. So I take your argument to be a pretty good one, at least in front of a jury, right? That like, we said digital arts, they should do it, right? It seems like a credible story, I get it. The rub that I'm having is maybe a little bit of the standard that we have at summary judgment, because there do seem things that cut against it. And Judge Motz points out our Simplewich decision. I mean, there are some significant differences there, but the question I'm at is, given what we've got, the retirement statement, Dean Haynes statements, and I get you can explain those, but I got to take them in the light most favorable, right? And the prior promotion to what I think of as full professor, I'm not sure that's the actual title, but you get the idea, that included this excellence in teaching, that had this sort of review aspect about, digital, performance. And I get that you've got explanations for those too. But what I'm having a little trouble doing is sort of saying that that's not a jury question. And I'm not sure which it is, but I want to get your take on, given that there are some cross-cutting sort of currents here, why do you think those two in particular, right, the sort of statements, categorizing it as retirement, might well be a mistake, but, doesn't look good, right? Dean Haynes' statements, right, might well be able to explain those, but they don't look great. And, the same thing with respect to, you just gave her the big, what they want to characterize as the big promotion the year before.
Right. Well, thank you, Your Honor. So I'll address those issues. I think the first thing I'll say is that the standard does not, under Rule 56, require that there be no dispute as to the evidence. And so if a reasonable jury could not conclude, based on the evidence, that the plaintiff should win, then summary judgment is appropriate. And our position is that, number one, while you do review the evidence in the light most favorable to the plaintiff, you still may only take those reasonable inferences from what's there. And I'll talk right in just a minute about what's there. But our position is that even if you resolve any dispute in favor of the plaintiff, if you take reasonable inferences from the few facts that you've talked about, there is just nothing there that a reasonable jury could base a verdict on and form as Palmer.
He says the promotion is the smoking gun.
Well, yes, Your Honor, and I think that Mr. Hawkins has this phrase of that wipes the slate clean, that somehow being promoted in the 2016-2017 school year means that nothing else can happen. I'm not sure for how long that immunity lasts, but
It's
nothing.
a big deal at a university to be promoted to a full professorship.
It is, and it is. Rank is important, and the professors themselves certainly feel that way. And she had been trying to get this rank increase.
So explain to us what your argument is then.
Right. So my argument is this: that first off, these are two different decisions. For one thing, a promotion decision is made based on this review of that particular individual's performance. And in this case, the undisputed evidence from the managers is that what they really were emphasizing with her was, if you want this promotion, you've got to, it's a must that you create some new artwork. And she did that. And frankly, maybe they shouldn't have promoted her, but they did, even though she didn't achieve these digital skills issues.
But wasn't there evidence that the digital skills were part of the calculus, right? That's why she'd been denied before. And so wouldn't we infer that that's why she got it this go around?
Well, I don't think you have to infer, because we
don't have to infer, right? Right. I get I don't have to infer, and you got a good argument. I understand that. But in this context, right, where like there is an inference.
I think you could take an inference that she at least did enough when you combine it with all of the other categories that promotion is based on, that they made a decision to go ahead and give her that promotion at that time. But the decision they were making over a year later, when they're deciding about whether or not to offer a contract for even another year hence, is not purely based on what Ms. Palmer's performance has been. It is a holistic view of what are the university's needs, what are students asking for. Students are more and more, and this is undisputed testimony in the record, students are seeking out these digital art classes. They are creating a situation where the university needs professors who have the versatility to teach those classes as well as the studio art classes that Ms. Palmer taught. And so this is why she's been repeatedly told every year, just about from 2013 forward, you need to improve in these areas in order to make yourself more versatile so that we can teach the classes we need to teach. And the testimony is they were having trouble even coming up with a teaching load for her because of her lack of versatility. And so, I'm not saying there's no tension between the fact that she got a promotion, but I think it's important to remember that the same people who recommended her for a promotion are the people who are supposedly harboring this age-based animus just a year later. And this is not a retaliation case where there's some sort of protected activity that happens after the promotion, and so it raises this inference that the management said, well, aha, we're going to punish you for that. This person was in this protected class all along. I mean, she was 78 years old versus 79 years old at these 2 points in time. So the judge, I think correctly, viewed that as really limiting any inference you can draw from the fact that the managers did decide to give her a promotion during this other time. And I do want to address, Judge, also your comment about or a statement about the comments, because it's really not even a comment. There is a chart that was created for the 3 people who were being selected for their contracts to be non-renewed, and there was a column, and one of them said retiring or retirement at the top. That was it. This was after the
I
selection.
mean, that says something. I mean, you can call that not a comment. I would call it a comment, right? There's a column. Maybe it's a column, but it sounds like a comment in the
Right.
column, right? Somebody put it there.
Oh, yeah, no, they.
And the people that weren't old, they didn't put it there.
Well, they didn't.
Excuse me, aged? What am I? I don't want to be, I'm sorry, I didn't mean to use the word old.
Why are you looking over here?
No particular reason, but
Well, then,
whatever the right word for old is, they didn't get that.
That word was put
Right.
on that chart by the Liberty managers. You're absolutely right.
so what is your argument about
My
that?
argument is that that is not tantamount to going to an employee and saying, aren't you ready to retire, or using retirement in some sort of negative connotation. And as was pointed out, the explanation, when you look at the, again, undisputed evidence, is that the reason that was done is that sometimes employees who are selected for non-renewal, if they're of retirement age, will ask, can I announce this as my retirement rather than it being a
But
non-renewal?
it doesn't say retired, question mark.
It doesn't, no. And ultimately, Ms. Palmer didn't bring that up, and so it was just processed as a non-renewal, just like the other 2 decisions that year. But there's really no reasonable inference there that age was even being considered, other than the fact that, yes, she was of an age where she might have been somebody who raised their hand and said, can I announce to my colleagues that I'm retiring, rather than have this be a non-renewal like anyone else. And so,
Can I ask you to shift gears just a minute? I want to make sure we get to it. You obviously made the ministerial exception argument first, and we've got them both before us now. And I'm a little confused about how the best way to go about resolving them. I think we can resolve it on either ground. But I wonder if you have a comment on the suggestion that, based on Lady of Guadalupe and Hosanna Tabor, where the court said that, like, judicial review of the way the discharge responsibilities with respect to teachers and educators, that just that review at all undermines the independence of religious institutions. And so whether there ought to be, purely as a matter of prudence or discretion, that if it's close, if what we've got here is like something that, we're going to have to actually review the decision-making, that in fact we ought to address the ministerial exception first to avoid intertwining ourselves in, if it turns out that the person's a minister, that we avoid intertwining ourselves or, second guessing, as Hosanna Tabor said, a religious institution with respect to their messengers.
Well, I think that's right. And in this case, obviously, there's no real dispute about whether it's a religious institution. Maybe that will be an issue in some cases that come before you. It's not really now. The faculty member, we're not here today to argue for a categorical statement that a ministerial exception applies to anyone who is a faculty member. But you're right that there is some difficulty in even approaching the issue from the court's perspective if the rule should be that there is too much entanglement if the court gets involved in determining how these duties are carried out. So you're right that if there is some sort of buffer around the really close calls, the court could avoid violating the First Amendment or having the case go forward. And one thing that I point out here is that if this is jurisdictional, then the university should have been exempt from being
Let's
sued.
assume it's not jurisdictional.
Okay.
I
Well,
think that's a safe assumption for you.
even from a judicial economy standpoint, our position is that the initial summary judgment motion on the grounds of the ministerial exception should have been granted at that point. And we point out that in
Saying
reviewing,
it should have been considered first and granted first, and you never get to the ADA claim.
that's correct,
Have you
Your
ever heard
Honor.
of Ashwander?
Pardon me?
Have you ever heard of Ashwander?
I have heard of it, Your Honor.
You know anything about Ashwander?
So our,
That's Supreme Court.
right,
That's way up there.
yes.
Supreme Court Ashwander decision, I think it's 1936 or something.
And this is trying to avoid deciding issues that you don't have to decide?
It says
Constitutional.
Constitutional.
we don't decide constitutional issues if we can resolve the litigation on non-constitutional issues.
Right, and,
That's the
But it-
Ashwander principle, as I understand it,
right.
and that's summing it up with a few words, but
And that,
But the Supreme Court said,
constitutional avoidance, I think the law professors and a lot of people call it the constitutional avoidance doctrine.
right, and as particularly as the appellate court, as you approach this case, you may decide, we are just going to decide this on the ADEA because the judge got it right, and we're going to affirm, and that's the end of it. Our argument here today is that you also address ministerial exception for the reason that it is sort of like the exception to mootness. It is likely to recur. This university is a religious institution in this district. The judge obviously doesn't believe it applies to faculty members under these circumstances. If you disagree, our argument would be that that would be something that would be helpful and allow the courts to dispose of cases in the first instance if a minister or someone who is a minister under Our Lady of Guadalupe comes forward and attempts to invoke one of the other employment laws.
What religious interest would be advanced if we apply the ministerial exception?
Well, I think it's the autonomy is the key word. It's the right of the court, of the religious institutions of the country to carry out their affairs without having the federal government or any government interfering in who they select for these certain positions. And the courts have made it clear that if we're talking about positions.
Yeah, but you stuck in there with their religious missions. So what does the non-renewal of Ms. Palmer's contract as an art professor have anything to do with Liberty's religious mission?
I see what you're saying, Your Honor. Yes, and so I know that early on in the development of the ministerial exception, there were arguments made that it should only apply where the employee is somehow running afoul of the religious interest of his or her employer, and that if it's a sort of garden variety employment case, it shouldn't apply. But that is not how Hosanna Tabor, for example, decided that issue. The question is
So
Ms.
your answer
Palmer-
is it doesn't.
No,
It
in
doesn't
fact, Ms.
matter.
Palmer was quite effectively carrying out the religious mission of the university. That's part of the evidence that she was in
Wasn't
fact.
fired
a minister.
because she wasn't carrying out the religious
Correct.
mission.
That's right, Your Honor. And our position is that that is fine under the ministerial exception because the ministerial exception is about, is she a minister or isn't she? And if she is, then she does not get to avail herself of employment laws when the university, the religious institution, makes a selection. I see I'm out of time, and so I'll address the rest on my reserve. Thank you.
Thank you very much, sir. We appreciate Appreciate you save some time too. Mr. Hawkins,
Yes, sir.
we're back to you.
Thank you, Your Honors. And I hate to be the bearer of bad news, but I think you are going to have to deal with the constitutional question. At least that's our position, because it's our position.
Assume for a minute that that's wrong, that maybe we could do both. I understand this is a hard place for you, but
Right.
Ashwander is obviously one of our cases that we rely on heavily.
Without a doubt.
Do you agree it's a prudential rule? It's not like a requirement that we do, it's prudential?
It is.
And that courts, the Supreme Court, sort of repeatedly has said, where there's a good reason to deviate, then that is a permissible course. In fact, the Supreme Court does deviate from that.
Correct.
And so what I want to get, I want to make sure the framework was there, but then what I want to get at is why wouldn't, the language from Our Lady of Guadalupe about, staying out of employment disputes and Hosanna Tabor, not second guessing that, courts have no warrant to second guess these decisions. Why wouldn't those indicate that if we're faced with a choice, we ought to stay out of these employment decisions, exactly as the Supreme Court has said?
Well, I have several responses to that. I'll start by saying your opening premise reminds me of Judge Easterbrook's comments in the Starkey concurrence, in the Starkey case that was recently decided out of the Seventh Circuit, and he expressed concern that courts were jumping to the ministerial exception first and dealing with non-ministerial exception issues later for precisely the constitutional avoidance reasons that you've raised.
Yeah, but the question then is like, if the ADEA claim was easy, right? If your claim was really weak, right? Well, I mean, I'm totally with you, right?
Right.
And so I got that. The angst is that the way you've presented the claim really requires us to second guess, like at a pretext level, a religious institution's employment decision, right? I mean, we have to say, in order to agree with you on the ADA claim, we have to say this religious institution, it is reasonable for a jury to determine that they are liars.
Yes.
Right? That they are dishonest in their dealings. And that puts us squarely, it seems like to me, in contravention of the Supreme Court saying that we are bound to stay out of employment disputes. Judges have no warrant to second guess those judgments. I mean, that feels like something that we ought not to do
Your Honor,
unless we have no other option.
well, I don't think you have another option. And I will tell you that if what you're espousing as a potential rule of law, if that were in fact the guiding standard, then that's exactly what they would have said in Hosanna Tabor and Morrissey Baru. Because every employment case, whether it involves a minister or not, involving a religious institution, involves some sort of unlawful activity. Age discrimination is unlawful. Sex discrimination
Why would they have said, I mean, they did say it. I mean, they said bound to stay out of employment disputes. No
ministers.
warrant to second guess.
Or ministers.
Well, correct.
Well, and that's the point. And so my point to you, Your
Mine
Honor,
is just an order of decision point, right? It's just a question of what is the order of decision. If you have a hard ADA claim, which requires us to second guess employment decisions, right, which requires us to get into their employment disputes, that is really difficult, we ought to default to the much easier, hypothetically, ministerial exception.
perhaps. Again, I think we're talking a little bit in academics because
No, of course.
what we're dealing
I have
with
a tendency to do that, I'm sorry.
No apologies necessary, Your Honor. What we have here is somebody who is clearly not a minister, and I think that resolves the issue so that you have to resolve both questions. This court has to say, at least from our position, has to say that there's a genuine issue of material fact as to whether or not age was a motivate, or not, but for causation of Eva Palmer's termination, and that in order for that proceeding to go forward, you have to say that the affirmative defense of a ministerial exception does not apply in this case. And I think you can say that, and I think Judge Moon got that point right.
Is that a legal issue or a factual issue?
On this record, I believe it is a legal issue. It's our position that Judge Moon could say, as a matter of law, that she was not a minister. And it's our position that if the words key roles and important positions and teaching the faith and messenger of the faith from Morrissey Baru are to have any meaning whatsoever, then they must mean that somebody must meet all three of those criteria in order to be a minister, and Eva Palmer meets none of those criteria.
Wait, I'm sorry, say that one more time.
You
Your position is that that list is, in order to be a minister, you have to be all three of those things?
You have to be in an important position and/or playing a key role. I think that can be interchangeable. But you must be a teacher or messenger of the faith. You cannot simply be somebody who
No,
supports.
that's right, but
the
you
institution's
let off
mission.
the list of three, like minister,
did.
whatever, and then you said you have to be all three, and that's plainly not true.
Well,
You don't have to be an ordained minister in order to be a messenger of the faith.
You do not, but you have to be in a key role at the institution. You have to be, and perhaps it's
No, but
redundant.
the key role is being a messenger, right? What Our Lady of Guadalupe says is that the key role is being a messenger of faith. That is defining what a key role is.
I think that may be correct.
Yeah.
I think
Okay.
I'm not trying to go too far, but I think the point that I'm making, though, is that the use of the words important and key mean that it can't be everybody at the institution. Everybody at the institution, if they were,
No, but I think we would say if you go into the Catholic Church, you go to the local diocese, like everybody in the local diocese is a minister of faith,
that may be true.
right?
Maybe.
So it's not that you can't have everybody in an organization be a key person in the sense that they are a messenger of the faith.
Correct.
Like there are some organizations that's all they do.
Correct.
Right? This isn't a rank order where you only get 50% can qualify, right?
I think that is correct. There's no limitation on how many people at one particular institution can or cannot be a minister. But I think the way that the court has analyzed the issue is that it does focus on important people, and important people are messengers or teachers of the faith. So, to very briefly say, the teachers in Morrissey Baru and in Hosanna Tabor were messengers of the faith. They taught from biblical texts. They taught students about the sacraments. They taught them how to believe. They taught them how to worship. They tested them on those issues. Eva Palmer did none of those things. She taught drawing. She taught painting. Her students learned how to do curvilinear and rectilinear changes. They learned how to draw lines. They were never tested on anything religious. And so for all of those reasons, as we've explained in our papers, she's not a minister. I want to close by saying what I think is the most important piece of this, which is that as we sit here today, no court of last resort, no state court of last resort, and no federal court of appeals has ever held that a teacher at any institution, at any religious institution, who has never taught religion or theology or doctrine or faith to their students is a minister. And this court should not be the first. We ask that the decision be affirmed. Thank you.
Thank you, Mr. Hawkins. We appreciate it. Mr. Tower?
Thank you, Your Honor.
Can you start with responding to that suggestion that there's a per se bar to considering a teacher a minister if they don't teach a class that is labeled separately religion or doctrine?
I think that just runs.
Or if they
right-
haven't proselytized at all. I mean, I thought that was included in the hypothetical.
Well, and I don't understand that to be a limitation that the plaintiff puts on this, but I think the evidence is that Ms. Palmer has prayed with students
In fact, prayed with students at the start of every class.
and I think more importantly, has incorporated a Christian worldview into, as she was expected to do and was evaluated on how she would do very well. She did very well at this, incorporating a Christian worldview into the material of the class. And art obviously is a course where this comes naturally. There's thousands of years of religious art. There is a reported case on a music director that I think is very similar in the sense that this is part of religion just in the same way as teaching from a text would be. And so
She has a syllabus. Where in your syllabus is that reflected?
I don't believe it's in her syllabus, other than in the general expectation that she is going to model this behavior, and she has in her promotional
Not
materials.
their job description kind of thing?
So it is not stated exactly what she is to do in specific in the job-related materials at Liberty. What she is given is the more general directive of you need to incorporate your Christian worldview into the classroom. There is training available from their Center on Teaching Excellence on this, and she gets the chance to do that. And so our view is that nothing in Our Lady of Guadalupe says, oh, well, you have to be teaching some particular text or else you're not a minister. In fact, I think the lesson of Our Lady is actually just the opposite. It's that you need to look at, is this a key role? Is this a role where this person is advancing the religious mission of the institution? And at least in the teaching context, we can say the answer is yes. It may be true that not everyone, unlike the diocese, not everyone at a university is going to be covered by the doctrine. We don't have to decide that today. We're not even asking for a categorical all faculty today. But this art teacher, with a record of her teaching in a way that incorporated her Christian worldview into the classroom, we suggest that you find does meet the ministerial exception, and that is within the Supreme Court.
We agree with you on the ADA claim. Wouldn't your position with respect to the other claim be asking us for an advisory opinion?
Well, I would agree that you would not need to necessarily decide the decision, the ministerial exception issue at that point. And our request that you exercise your ability to do that is based on what was being referred to earlier, that Ashwander is prudential, that there is a real judicial economy when someone's status itself causes them not to be, the suit not to be amenable, as opposed to a potentially messy set of facts of, is there a protected class that's being relied upon? Is there a legitimate reason? All of the things that come along with your normal employment case. When that one yes or no status question would resolve the issue, we think that the district courts ought to be able to reach those first, and so we think that your decision giving them guidance on both of these issues would be important in that regard. Your Honors, I did just want to address one or two other things that came up. The Plaintiffs' Counsel indicated that one of the reasons that they believe that this case is not well taken is that there was not a specific threat essentially made to Ms. Palmer that if you don't gain these skills, you will be discharged in some sense. And I think that that's just nowhere in the case law that there's an obligation on the employer to threaten to discharge, or else they can't rely on a fact, or it's not a legitimate non-discriminatory reason if there's not some specific communication of that type of warning. So I think that years of telling an employee, this is what we expect of you, this is what we need you to do, and having them, by concession in argument today, not achieve that goal, that's a legitimate reason for...
When they promoted her, did they once again say, we want you to get this digital stuff under your belt?
I don't think they made that in simultaneously, you're promoted, but you still need to work on
Right.
this, and maybe that is something they should have said, but I don't think it wipes the slate clean and takes that issue off the table.
Okay.
And so for those reasons, Your Honor, we think you should affirm the district judge on the ADEA issue, and we would specifically ask that you not only reverse the grant of summary judgment to Ms. Palmer on the ministerial exception issue, that obviously one option you have is to simply reverse that and send it to the jury effectively, but we ask that you reverse the denial of summary judgment for Liberty as well on that issue.
Thank you very much, Mr. Tower. We appreciate it. We appreciate both counsels, the counsel on both sides. Good efforts in this case, and we thank you very much. Number 2257. Pond versus the United States. Mr. Adams,
Yes, Your Honor.
good to have you with us, sir.
Thank you, Your Honor. May it please the court, I am Jimmy Adams from Guilford County, North Carolina, Greensboro. Along with me is Dan Colston. We have the honor of representing Stephen Pond in this matter. Your Honor, the issue before the court today is whether Mr. Pond's July 2017 mailing of his Form 1040X tax return for the 2013 tax year was delivered to the IRS sufficient for him to be entitled to a refund for taxes claimed and paid in 2013. The government in this case has conceded the substantive tax issue. And we know that because Mr. Pond, based on the same computational error, relied and filed a refund claim for 2012, and that was paid. Instead, the IRS, based on its own regulation, Treasury Regulation 301.7502-1 says Mr. Pond's July 2017 mailing was late or did not arrive, and therefore they don't have to pay what is otherwise they would have to pay. And the district court, for the same reasons the IRS relies upon, said that the district court did not have jurisdiction to even consider whether Mr. Pond was entitled to the refund. And so there are two fundamental issues for the court today. Number one is the IRS regulation entitled to deference under Chevron versus Natural Resources Defense Council, such that the regulation should be allowed to stand as is. And secondly, even if the regulation exists, did Mr. Pond plausibly allege facts that establish actual delivery such that he satisfied the delivery standard notwithstanding the regulation? And, Your Honor, I propose to start with the Chevron issue.
Before you start with Chevron, before we talk about Chevron, we read the statute, right? And it strikes me that the statute itself is quite clear that in a case where there's no actual delivery, you only get a benefit if it's certified, right? This is C, right? Subsection C.
That's what the statute, that is a way the statute has been read, Judge Richardson.
All right, but just let me start with this premise. If I believe that was abundantly clear, that the statute was unambiguous, that A deals with timeliness when actual delivery, C deals with late delivery, then why do I even look at the regulation or any of these questions, right? All the rest of these things go away, am I right? If the statute is clear that the language says what it says.
That's absolutely right, Your Honor. If the statute is clear, then Chevron and all of the cases decided under Chevron would say you never have to get to the regulation. And in fact, it would say the regulation should have never been promulgated in the first place because it's unnecessary, because the statute...
Well, Chevron doesn't say the regulation shouldn't be promulgated. The executive can do whatever they want to do. The point is the regulation just doesn't matter.
Correct, Your Honor.
So help me understand your argument for why there's ambiguity. Because when I read A and C, they seem to be quite clear to me. And so help me understand, before you get to Chevron and, all sorts of other things, why is there ambiguity?
Well, so, Your Honor, let's back up for a second. So,
why don't we start with the text instead of backing up? Why don't you point to me in the text where I can find some, hope of ambiguity?
Well, Your Honor, the text of the statute, first of all, the Supreme Court has said, all the way back to Rosenthal and other cases, that Congress is presumed to legislate in the context of the common law. And so you have to start with Congress's assumption that the common law exists in the first place, and that Congress is going to then legislate and select text.
But that doesn't overcome clear text, right? The point of that is it doesn't trump what we have described at various points. The Supreme Court has described as this presumption, because where the text speaks directly to the question, right? That's U.S. versus Texas, the most recent discussion, where it speaks directly to the question, then the presumption goes away. That's why it's a presumption, not a rule. And so if the text speaks directly to the question, that is, I might say here, whether regular mailing or certified mailing is required to get the benefit of a delivery presumption, the text is like remarkably clear in speaking to that very question in C.
Your Honor, I would submit that the text is not clear on that at all.
Maybe we could look at the text
Right.
together.
So, Your Honor, if you start with, Your Honor, you're looking at subpart C, registered and certified mailing, electronic filing. For the text to be considered to be clear, you have to treat that as a standalone provision. You have to be saying that Congress wrote this in such a way that the only way that you get a presumption of mailing under any circumstances is if you have registered or certified mail in the situation where it's not actually
No,
received.
I read it in the context of A as well, right? Because A is the other side of this, right? So where there's actual delivery, but there's a debate about timeliness, we got a whole set of rules that apply to that, right? And you might, be able to show actual delivery. We'll talk about that claim separately. And so you might get the benefit of A if you're able to show actual delivery, which hypothetically you might have plausibly alleged here, right? So you might fall under A. But for the argument you're making about 7502, as I understand it, you're trying to rely on C to say even if there's not actual delivery, I still get the benefit, right? I get the benefit of a presumption of delivery, not of timeliness.
That's correct, Your Honor, because the common law mailbox rule presumes that if you place an item in the mail, properly addressed, properly postmarked, the Postal Service will actually do its job. And so the courts have said we are going to give the risk of loss in that situation, we're going to assign it to the Postal Service, that they're going to assume they're going to do their job, and that the taxpayer...
That might well been the common law rule, but then 7502C comes in and says, yes, that rule applies. That very rule applies, but only where it's by registered mail, right? Or maybe certified mail too, but we'll just focus on certified or registered mail, right? It only applies in that circumstance. So it's spoken to that very question. It's not any mail. It's really easy for your client to do, right? You just send it by certified mail, right? Something that, we all know how to do.
Your Honor, what I would submit, delivery has to occur first, and then the question is when it was delivered.
No, that's A, not C.
Exactly, Your Honor. And that's the reason Congress drafted the statute the way they drafted it. The statute was intended to handle those situations where you're mailing it from different parts of the country or different parts of a location, and ordinary routine mail might get it there in time, and it might not get it there in time. So what Congress did, it created...
That doesn't have anything to do with C.
Yes,
right?
Your Honor, it does.
What? Help me. I don't understand how that... Because C is only about a question where it's certified, right? So you got certified mail, and if there's no delivery, right, we'll presume it was delivered, right? That's as you put it, like the liability on the post office, not actual liability, but we put the responsibility on the post office.
Correct, Your Honor.
Right, that's fine, but that doesn't have anything to do with timeliness.
And Your Honor, and we are not relying on 7502 for timeliness. The deadline for this filing was October 28th of 2017. It was put in the mail on July the 18th of 2017. Plenty of time to satisfy the timeliness requirement. We are not relying on 7502 to show this was timely whatsoever. But to your point about the regulation.
So can you tell me how you fall under, or maybe you agree you don't, how you fall under, at least ambiguously fall under the text of 7502?
We don't need it, Your Honor.
So you agree you do not fall under the text of 7502C?
Well, Your Honor, it is our contention.
No, well, let's start with the question, right? Do you agree you do not fall within the text of 7502C?
We did not mail, our client did not, his accountant did not mail this registered or certified.
So the answer is yes. You admit that you are not under 7. Okay.
Yes,
so then tell me why we're not done.
Because, Your Honor.
On this claim, I get the actual delivery claim.
7502C is just a safe harbor, which the Baldwin Court in the Ninth Circuit relied on, the Third Circuit has held that, the Eighth Circuit has held that, the Tenth, all of the courts that have actually done a deep dive onto this issue have concluded that the common law still existed when Congress passed 7502 in 1954, and that C was only a safe harbor provision for people that were, for example, you could mail it on the last day, and if it arrives, you're good. But if you mail it on the last day, even giving the mailbox rule that says routine, if they don't have actual delivery, 7502 would say you're out of luck. But there's a safe harbor, and that's the language that's used in the Anderson case and even in the Baldwin case and the Sorrentino case. You have a safe harbor that allows a taxpayer to use registered or certified mail to get over that hump when you're filing it late in time to satisfy A. And so, Your Honor.
Why do you
So
read?
how does that help you?
Because we don't need 7502 at all, Your Honor.
Okay.
Because of the common law mailbox rule.
Relying on the mailbox rule.
We are relying on the mailbox
You're
rule.
saying you mailed it by regular mail on October the 18th,
On July the 18th, Your
July
Honor,
the 18th,
which was,
and it had 10 days to get there,
right, and we had 4 months to meet the deadline.
4 months to get there.
Because there was a 4-month window that the deadline.
Common law mailbox rule, it should have gotten there within 4 months.
Yes, Your Honor. And the rules of construction of statutes, you have to presume that,
There's a presumption that to put it in the mail, it's delivered.
yes, Your Honor. We presume the Postal Service,
I remember, I think from law school, they told us that the statutes in derogation of the common law must be strictly construed.
correct, Your Honor.
Is that still a principle of law?
Yes, it is, Your Honor. And the Supreme Court has been very clear.
So does that mean they had to say we are repealing the mailbox rule? Is that what your position is?
They didn't have to say we are repealing, Your Honor, but the language
Right.
from.
All they had to do in Texas is speak directly to the question, right? They speak directly to the question.
Your Honor, the language from the Supreme Court Norfolk redevelopment case, 1983, is that the language must be clear and explicit for this purpose. And if you look at the language of the statute, C is even limited to for purposes of this section. And the point of A was to assist, was to help taxpayers. It wasn't to hurt taxpayers. It was to give taxpayers the assistance of being able to file late and still be on time. And so, for example, in the Philadelphia Marine case of the Third Circuit was quite clear. It said it's difficult to imagine Congress, by passing a law that was designed to protect taxpayers who meet 7502 requirement, would simultaneously eliminate a rule that had been in place for decades and allow them to have the common law mailbox rule. In fact, Your Honor, 12 years later, 14 years later, Congress amended the statute, and in the legislative history in its committee report was quite clear that registered and certified mail was not the only way in order to prove mailing. Now, it was in a different context.
You could have delivery, right? That's another way to prove mailing, right? If the IRS receives it.
You have electronic mailing.
Well, but Your Honor, there's a difference between delivery and the IRS saying that there was delivery.
And I totally get, I'm happy for you to talk about it. I totally get that you may well have plausibly alleged that there was delivery here, right? And you may get to have that fight. I totally understand that argument, right? But that's not responsive to this one, right? The fact that the IRS says that they can't find it in the system is not quite the same thing as saying it was never received. I get that. But that's not responsive to this argument.
Well, Your Honor, that's a factual question as to whether or not, but the legal question is, does the mailbox rule still exist? All of the other circuits that have examined this in any detail have said, yes, it existed. Baldwin then goes on to say, well, it's that the statute was not clear, and so the IRS had the latitude to make to pick which way they wanted to go, which we would submit would be wrong itself, because the IRS or any other administrative body does not have the authority to decide we're going to keep the common law or we're not. the Supreme Court has been quite clear that Congress and only Congress has the authority to decide whether the common law is in or the common law is out.
And it does, do you disagree with the premise that when Congress speaks directly to the question addressed by the common law, that the canon of common law derogation is abrogated? So it doesn't apply. That the precise language is where Congress speaks directly to the question addressed by the common law, right? And I read 7502 as speaking very directly to the question of the common law mailbox rule. It is a statutory version of the common law mailbox rule. It's even got the two parts, A and C, which match on to the two parts of the common law mailbox rule. So it is spoken very directly to the question of what's the scope of the mailbox rule. And for purposes of C, it says it only applies if it's certified mail. Regular mail doesn't get you there.
Your Honor, we would submit that the statute does not speak to the common law mailbox rule because the common law mailbox rule presumed delivery in a regular time, whatever the regular time would be. And the cases
That's exactly what the C does for certified mail. It does exactly that for certified mail, but only certified mail. To take advantage of that rule, you just have to do it by certified mail. It costs you an extra 35 cents or something. I don't know what it is, but like you get the little green piece of paper, right? Like this is not like a complicated story, but to avail yourself of the mailbox rule, you got to do it by certified mail. That's what 7502C tells us.
In your Honor, the Miller case out of the Sixth Circuit agrees with you. All of the other circuits that have looked at this in any significant way disagree and conclude that C was a safe harbor, that Congress did not abrogate the
They
common
wrote
law.
the regulation then.
Which is what, but Judge King, that was the second error. Because the IRS does not have the authority to decide to get rid of the common law. The Supreme Court's crystal clear. The only entity that has the authority to get rid of the common law is Congress itself.
So you say the regulation's no good.
Yes, sir.
But I got another question, and you know you're getting here past your time, but you all were entitled, your client was entitled to a refund.
Yes, sir.
Why did they have to file a claim for a refund? I thought the IRS was obligated by law to send them a refund, period.
Well, Your Honor, that was...
Without a claim, and you raised that in your brief on page 16 and 17, I think.
Yes, Your Honor, we
I thought,
we
if I ever was entitled to a refund, they made me a refund.
so, Your Honor, the IRS's position is, well, the statute we say is clear that in this context involving a
Why are we
partnership,
here if they're obligated to pay you a refund? It's your money.
because they've said they don't have to pay us.
You don't get it because you missed the statute of limitations. Well, what happened to your money? Is it going to the national debt or been forfeited in the United States, going back to the general fund? I don't know, but it's a debt owed by the United States to your client because it wasn't a tax liability.
That's our position as well, Your Honor. The IRS is...
Why isn't that the big issue here?
Well-
I don't know why we're here. If they were obliged to pay you the refund.
Well, the issue, Your Honor, as I understand it from the IRS's perspective, and the district court said because they agree with the IRS, the court said it didn't even have jurisdiction to look at this issue, let alone look at the facts. But the internal...
The district court's jurisdiction is limited to where it is duly filed, right? That's 7422.
Yes, sir.
And so it might be that you don't have to, but you can't get judicial review without having duly filed it.
Right, so it's a double whammy. Number one, you don't get the return, and number two, you can't get anybody to look at it and say whether you should have gotten the return or not.
Yeah, seems unfair, but also seems like what the statute says, right?
It's what the statute says unless you deem you get your refund in on time, and accept yet another example. The other statute, 6230, says in the context of a partnership return, which is what this was. So there was an audit of the partnership, and the IRS messed up the audit and told Mr. Pond he owed more money when he really didn't, says that in that context,
And Mr. Pond had messed up too, so it turned out like nobody got it right.
well, he paid something he shouldn't paid. That
Right.
was a mistake. But he should have been able to get his money back, and he didn't mess up. He did exactly what the IRS said in
I mean,
publication
originally.
17.
So he messed it up. The IRS thought he owed more. Turns out he owed less.
No, Your Honor, he's just an investor in that partnership. He's not an active
I don't mean
participant.
him, the partnership.
Yes, Your Honor. But, Your Honor, and I know I'm out of time, but
How much money is involved?
about $145,000, Your Honor.
Thank you. I didn't mean to interrupt you.
So, Judge King, let me just finish answering your question. There is another provision in the statute that says that it's a 26, and I wasn't going to, 6230, that in the case of an overpayment by a partner attributable to a partnership item, which is this case, a refund of such overpayment shall be allowed without any requirement that the partner file a claim. And
Then then we shouldn't even be here. Why
and
did the government, why did somebody say there's no case or controversy?
the government's position on that is we didn't raise that below.
Well, okay, so you raised it in your brief here, but you didn't raise it in the district court.
We did not cite to
All
that
right,
particular
so
statute
you waived
below.
it, so that you could waive it,
Well,
create a jurisdictional basis for a.
Your Honor, we don't consider that we
federal
waived it.
Lawsuit by nobody understanding it?
That's an additional methodology for which the IRS was on notice.
We have to look at jurisdiction first
Of
of
the
all and foremost.
Yes, Your Honor. And our position is that when,
But if we throw it out for lack of jurisdiction, what's happening to your money?
the government gets to keep
They
it.
still owe you money?
No, Your Honor, if we don't have the ability to go and get,
No, but they owe it to you.
they still owe it, we just can't collect it.
Okay. Well, you've taken, I got you stirred up here for another extra 6 minutes. That's all right. You saved some time back for a rebuttal.
All right. Thank you, Your Honor.
Mr.
Willie.
Willie? Mr. Willie, good to have you here.
Good morning, Your Honor.
Yes, good to have you here, sir.
May it please the court, Robert Willie on behalf of the United States. This case is about ensuring there is a clear, easily applied standard for determining whether a document was delivered to the IRS and then applying that standard in a logical manner. The district court's decision should be affirmed for 3 reasons. First, the court properly recognized that Mr. Pond's complaint should be dismissed because he failed to allege that he has direct evidence of actual receipt of his claim, and he otherwise failed to include a non-conclusory allegation of actual receipt in his complaint. Instead, he attempted to circumvent the Treasury regulation by using circumstantial allegations of document mismanagement to raise an inference that the IRS received and then destroyed the document. But this inference is insufficient to establish actual receipt and unwarranted in any event. Second, the court properly rejected the application of the common law mailbox rule, although it did not have to resort to Chevron deference to do so. The text, structure, purpose, and history of Section 7502 all suggest that Congress intended that it constitute the exclusive exceptions to the physical delivery rule. The statute reflects a desire by Congress to have a clear, easily applied rule in this area. This makes sense as both taxpayers and the IRS benefit from clear standards in this area. Third, even if the court determines that Chevron deference should be applied here, there can be little doubt that the IRS's construction of the statute is a reasonable one. It's the construction of the Second and the Sixth Circuits. That alone should show it is reasonable. But as the Ninth Circuit also recognized in Baldwin, an agency's adoption of one of 2 competing canons of statutory construction is not unreasonable.
Can you go, if that's the list, can you go back to the first one? I have a little trouble understanding why they haven't plausibly alleged actual receipt. And it sort of seems like to me it sort of stems from a couple of things. They made the factual allegation that they mailed it, right? And so we know that piece of information. They do conclusory then say it was received, right? But they give evidence to support that it was received, right? And so one of those pieces of evidence is that they sent 12 and 13 together, right? And 12 is deemed timely filed and paid, right? And so from that, we could assume that the IRS received 2012. Fair?
I disagree with that characterization.
Well, you think there are two plausible inferences. One is that they received the 2012 from that mailing. The other is that they received it from the Andover discussion.
No, Your Honor, they resent 2012 before the statute of limitations.
But how do we know? They sent it on October 3rd to Andover, right? And so maybe the IRS got it from the October 3rd at Andover, but maybe they got it from July 18th. Either of those seem to me to be a plausible answer. And then you combine that with the idea that the IRS chose July as the date that the 2013 application was received, right? Suggesting that, it was around the time of July. And then the IRS responds not by saying, we have evidence that it was not received. They instead respond by merely saying that I can't find it in the system, which, is not like a terribly shocking thing given sort of the calamity of errors that we've seen. And so you might well be right, but how is that not a plausible allegation that it was received when you've got the 2012 and you've got the IRS dating it in July, the 2013 dating it in July, that putting those together, that's a plausible story. And you got to do discovery, and maybe at summary judgment you can prove that they're wrong.
Well, but with respect to the dating it in July, what it said is date of claims received July 17th, 2017, and they allege they sent it on July 18th, 2017. And so
Right, and your view is, well, that necessarily means because our people are perfect, right? That it couldn't possibly be our mistake in dating it on the 17th instead of the 18th. It must mean something else. And that might be right? It might mean that your people are perfect and that they could not have made that mistake. But a plausible inference, on the other hand, is that your people wrote down the wrong date. I don't know. We know if your theory of the case is right, they didn't receive it in July at all. So whether they wrote the 17th or the 18th or the 21st, I'm not sure why that helps you. At the motion to dismiss stage.
We're not relying on that necessarily to help us, but you're
relying on it to undermine. You're trying to say our guy couldn't possibly have wrote the 17th because they didn't mail it until the 18th.
No, we agree that our guy wrote the 17th, but he
couldn't have meant that it was received that day, right?
Right, but they also don't allege that he meant that it was received that day. They allege that the agent who received a duplicate fax of the copy in 2019 somehow went back and found the original filing in the files.
Is that their allegation? Where did they say that in the complaint? I don't take that to be their allegation at all. That's your defense. Might work in front of a jury, right? But they don't point to the complaint where they allege that what happened was in 2019, the guy went back and found the date, and that's the date he put on. I don't know how they would know that to allege it, and I don't recall it being alleged.
Well, I'm saying that is the inference they're trying to draw from the document, and that's the
inference you're trying to draw, not them.
If they want to use that to say that what the document means is we actually received the claim. If they want to use that, then that's the inference they're drawing to interpret that document. Because again, it's undisputed that date is wrong, and so the question is, can we derive some sort of other inference? How can we read into the document to infer something that's not on the face of the document?
It does indicate you got it, whether the date's wrong or not, doesn't it? It indicates you got it. You put on there that you got it.
It does. It does.
Put it on an official IRS record that you received it. an official IRS record. You put on there that you received it.
It indicates a date of a claim received, yes.
And if that date was correct, it would be timely filed.
If that date was correct, it would be timely filed, but, I mean, we know
You
that.
chose the date, right?
We know that that date is not correct. And, the question, though, is, have they met their burden to plausibly allege a waiver of sovereign immunity? And so, in terms of actual receipt, if you look at what they need to show to allege actual receipt, then it needs to be, as it is said in Maine Medical, the IRS actually coming across the document in its files. And
I'm sorry, so your view is the only way they could plausibly allege that you received it is if the IRS finds it in their files. So it's really, they can't plausibly allege it. They rely on your grace in admitting to them that you found it in your files. Otherwise, they can't even allege it.
Not necessarily, Your Honor. Taxpayers could file a FOIA request before they file their complaint to see if they could uncover in the files. So, there are avenues for that. But again, it is.
Does the IRS respond to FOIA complaints for people's tax returns?
Taxpayers generally have, FOIA rights to request their.
He could request the partnership's tax. I don't know why it matters whether he can do a FOIA or not, but
copies of.
Copies of the receipt logs, like the mailroom logs for July. If they sought the mailroom logs from July from the IRS, you say they could get that by FOIA. That's the IRS's position?
I believe they could. I believe there are other mechanisms that taxpayers can use for investigating some of the things. But you can also have a situation where before you file the complaint, what you would have is if a representative of the IRS actually did communicate to you that the complaint or that the claim was actually received.
Right. Yeah. I get if the IRS, by its grace, acknowledges that. That's fine. But the question is where the IRS denies it and they want to disagree with it, right? And I'm with you that you can't have some broadly conclusory claim, but it seems like they've got a claim backed up by facts. And then, instead of a FOIA, they do a deposition, right? That seems like to me the way litigation typically works.
Well, but we're talking about a jurisdictional analysis.
All they have to do is plausibly allege, right? Plausibly allege that you received it. And they've got facts. I don't know how good they are, but they seem somewhat plausible, no?
What date do they say you received it?
Well, they don't provide a date that they claim we actually received it. I don't know what they don't. I don't believe in the complaint have a specific allegation that we received it on this date.
What about their claim that they didn't have to file a claim anyway?
Correct. They didn't raise that in the district court.
It's jurisdictional. So I didn't know they could. It goes to the jurisdiction of this court, doesn't it? And the district court. That always has to be considered.
Well, it would be.
Have to file a claim. What's this case doing in the federal court system? You owe them the money. You being the United States of America, you got $125,000 of the partnership money because there was an overpayment. And somebody ought to go back to the partnership some way or another, collect it. They can use it to hire somebody and do whatever kind of business they're in. It's their money. It's not the United States money.
Do you agree with that?
Owe it.
Well, Section 7422 requires that you file a claim in order for the court to have jurisdiction.
In other words, what you're saying is that there's been a forfeiture because there wasn't a timely filing of a claim. Is that right?
We're saying that Section that there's a statute of limitations in Section 6511, and the Section 7422 then requires a timely filed claim in order for the court to have jurisdiction.
No.
And they-
Do you owe them the money, or do they forfeit it by not making a claim? They say in their brief on appeal that you were obliged, you, the United States of America, to pay them the money because it was an overpayment. You were entitled to a refund it. They were entitled to a refund from the United States, and they didn't have to file a claim. Did they have to file a claim? And if they didn't file a claim, was that a forfeiture to the United States of America of $125,000? That has to be your position. They had to file a claim or they forfeited the money, and if that's the law, you need to give us some support for it, I think. The fact that you say they waived it, there's no waiver that gets you in a lawsuit and creates jurisdiction, I don't think, like that.
No, I mean, we also say as a substantive matter that they did have to file a claim, because
But
Section...
file a claim for money that you were already obliged to pay them. I mean, everybody's had experience, maybe not everybody, with refunds, but when if they overpay their taxes, a lot of people have experience, they like to get that refund check. The government sends it back to them, and they don't file any claim for reimbursement.
Correct, but the district court in Whittington, that we said on page 48 of our brief, addressed the issue and said, under the terms of the statute, whether a claim under the section is required without a refund request is contingent on the government's determination that such refund is practical. And the district court in that case interpreted that to mean that it was not automatic, and that it didn't somehow waive the statute of limitations and the requirement that you have to have a timely filed.
Couldn't both things be true? Couldn't it be true that you don't have to file a claim in order to get a refund? But it also is true that in order to avail yourself of a federal court, that you must have filed a claim?
That's correct.
That's the situation we've got. Like, to get a refund, you don't have to file a claim. But under 7422, in order to avail yourself of federal jurisdiction, you have to have filed a claim.
Yes, that's correct.
Now we know what your position is.
Yes.
But why didn't you say there's no case or controversy between the United States and them, because you owe them the money and it's on the way?
I guess
Everybody would understand it.
Well, I'm not quite following. Why didn't we say there's no case?
Well, because you're the defendant, and there's no case or controversy. If you owe them the money and you're paying it, then the statute of limitations issue is moot. It's irrelevant.
But that's not what you said.
Well, but we filed a motion to dismiss for lack of jurisdiction.
So you did say lack of jurisdiction.
I mean, I guess-
You didn't raise that point of lack of case or controversy. There's no controversy between you and them if you owe them the money, because you're going to pay it. If you owe them, if they overpaid their taxes,
I guess-
they're going to get it back. That's the way it works, I thought, with the IRS.
I guess you're suggesting that we should have filed the motion to dismiss because there's no case or controversy, because we planned on paying it to them?
Right, and is that correct?
Because that,
Are you planning to pay them the money?
no, Your Honor.
And why not?
Is it their money? It is their money.
What was their money?
It wasn't.
His answer's was, your answer's is.
But, so because they didn't make a timely, I mean, what is the reason? First of all, do you acknowledge that they would be owed the money? That they have overpaid their taxes and they're due, because of that, they'd be due a refund? Do you acknowledge that?
Yeah, I don't dispute that.
Okay, so why isn't the IRS giving them back the money?
Because they did not timely file a claim, and because the statute of limitations for filing a claim nonetheless has to be honored. I mean, this is not a circumstance that never arises. I mean, if you might be entitled to money, but if you don't file your claim for refund within the statute of limitations, then the IRS would not pay it, even if you make out a pristine case that you're entitled to the money. As a general matter, if you don't meet the statute of limitations, then
So the IRS can refund money without the assistance of a federal court, right? And I assume does.
Right.
A lot of times. But if it hasn't done, from some reason, even its own error refunded money, the person must make a timely federal court action to get the money. Is that correct?
yeah, that's correct. I'm not aware of any practice by the IRS where if they get a late filed claim that they would consider that, well, maybe they really are entitled to the money. And in this circumstance, for purposes of equity, we would provide it to them. As the district court.
So there are no exceptions to this rule, is what you're saying? If the IRS doesn't voluntarily give you back the money, you have to file for it, and if you don't do that in a timely manner, you're out of luck.
Correct. If you don't file a claim within a timely manner, then the IRS doesn't decide that they might.
So it's a different rule than the individual taxpayer? If I overpay you for a tax year, overpay the IRS, there's a question of whether I want to check or apply it on the following year or something. And I get credit for the money. Is there a different rule for a partnership or something, that they have to file a claim rather than having a check sent to them or having it applied to their next year? Is there some different rule that entitled, and you're saying, you're telling us, and this is a federal appeals court, that if this $125,000, the United States of America is entitled to keep, it's forfeited if they failed to file a timely claim for a refund, that they weren't entitled to have a check sent back to them, that with the money that belonged to them. You're saying that that's basically taking money that doesn't belong to the government and putting it in the government's pocket. Exactly what it is. And they know it doesn't belong to them, but they're resting on the technicality of the day or the count of the statute of limitations, which we were up here arguing about in a federal case that maybe shouldn't even be here if there's no case or controversy. If you all owe the money and it's not yours, it belongs, and you know exactly who it belongs to. It's not like it's going into the government's pocket because they don't know who it belongs to. It belongs to that partnership that overpaid the taxes.
Correct. But, for example, if I file a tax return and then I wait more than 3 years and I file a claim for refund, the IRS will.
That's where the amount's disputed or something. There's an issue about whether they overpaid. There's a matter in dispute. They want to file an amended return or something and get some of the money back. But here they've told them it's over. We know you overpaid. That's the way I understand the facts here.
Is that wrong?
You just said $125,000. You brought up the $125,000.
Well, I don't know that the IRS hasn't done a substantive review of the claim.
Well, I think they say something exactly like that, and you're the only ones we got here, and you're the IRS. You speak for the IRS. That's your client, the United States of America.
Right, and I don't.
We like the United States of America to fulfill its obligations.
So is it your position that, I just frankly don't understand your position. Do you acknowledge that the IRS owes them some money in the refund? And if so, do you come to the same amount of money? Or do you say that, no, you don't owe them any money? Leave aside whether it was a timely, we'll get to that in a second.
Well, the IRS hasn't done a substantive review of the claim for refund.
So it denied it because it wasn't timely. So there is no acknowledgement that you owe them the money, is that it?
Is it-
By the IRS?
Right, we haven't come to a determination, the IRS didn't come to a determination that it is the amount of money that they're owed as a substantive matter.
Well, is there something that you've done it as a procedural matter? What are you talking about? Why did you say as a substantive matter?
Because it was denied on the statute of limitations basis before there was any substantive review
I see.
of the claim.
I thought you told them earlier on that when in connection with the 2013 return, that there was there's $125,000 overpayment. And they waited too long, you say, to ask for it back. But you had the obligation to give it back to them if it belonged to them.
We did pay back 2012.
That's the only point I'm making.
But did you say?
And if that's the case, the federal court's going through the motions here.
We refunded 2012. They're claiming a carryover to 2013. And so the carryover has not, it was denied for 2013, was denied on a procedural basis, not based, but there was not a substantive review of that done.
Well, their brief argues that they didn't have to file a claim. And in the federal, didn't have to file a claim with you all, at all. That they were entitled to have it paid back, the overpayment, either by having it credited to some, I guess, their account, or by getting a check. And your only response to that is what you've said here today, that it was too late or something.
Correct.
No, your response to that was they didn't raise it below. Your response to that was they didn't raise it below. Well, if it's jurisdictional, they can't waive jurisdiction. I'm telling you that right now. I understand enough law to know that. The federal court has to decide its own jurisdiction. And if there's no case or controversy, that's in the Constitution of the United States. There's no case or controversy, we don't have any business getting in it.
Correct, but
If you owe them the money and it's their money, you owe it to them. If you don't dispute that you owe it to them, you don't have a right to steal it from them.
You are now saying you're not admitting you owe it to them. That has not been determined by the IRS.
That's not been determined by the IRS.
Right.
But you've not defended this lawsuit on that ground. You've instead defended the lawsuit on the procedural ground.
Right, we've defended the lawsuit on the procedural ground. Unless the court has further questions.
Thank you very much, Mr. Willie. Mr. Adams?
Thank you, Your Honor.
Can you start with this question? Right, so I understand your argument under 6230, right, D, whatever. But I don't understand how that has anything to do with our jurisdiction, right? 7422 gives us limited jurisdiction, right? This is the jurisdiction we have, and it requires a duly filed claim. And so I don't see how 6230 has anything to do with our jurisdiction and how it could overcome or trump or change our jurisdictional grant, which I assume you agree is 7422.
Yes, Your Honor. So our position on 6230 is the statute waives the filing requirement. And so therefore, we didn't have to actually file a claim in the first place. We had an original opportunity to go to the court to say, the IRS should have sent us the money.
But you have to have an actual grant of jurisdiction, right? So we only have the jurisdiction that Congress gives us, right? And Congress gave us jurisdiction under 7422 to address these claims. And so no other statute, 6230 doesn't grant me any jurisdiction, right? I have to have a jurisdictional grant. You got to point to a statute that gives a federal court power. And the only statute that you've pointed to give a federal court power is 7422. And that requires a duly filed claim.
Yes, Your Honor, and we did file a claim. And so what 6230 is,
Duly filed.
we would.
And that's the debate. I get that's the debate. You think it's timely and it's not. But I think the point being is that if it's not a timely filed claim, we lack jurisdiction.
And Your Honor, our position is twofold. Number one, the statute creates the claim by waiving the requirement of a filing. The IRS.
How does it create a claim by waiving a requirement?
It says that to the extent practical, credit or refund shall be allowed or made without any requirement that a partner file a claim therefore.
Right. That means the IRS can do it as a matter of grace. Right. They can choose to do it. That's great.
Right.
But what it doesn't do is give me any jurisdiction.
And so, Your Honor, with respect to that one, we did file a claim. And the IRS was on notice of it by 6230, and so therefore it was timely. And so they don't get to rely on October 28, 2017 to say it was timely. It was timely when the IRS messed up under 6230. The filing of the piece of paper was just a procedural property that we had to send them a piece of paper.
Procedural necessity for us to have jurisdiction.
But it was timely. It was timely when made, whether it was received or not. I mean, there is absolutely, it's crystal clear in the record that the IRS has received a copy of the 2013 1040X.
Totally with you, but the whole argument, you're not saying that 6230 means you don't have to file a claim to get into federal court. You're saying instead 6230 means that it's timely even if it's after the time that would otherwise be provided.
Otherwise, this statute means nothing. Yes, sir.
I don't think, it means that they're entitled to do it as a matter of grace. It still wouldn't mean that regardless. It wouldn't have to affect federal court in any way because it would grant the IRS the authority as a matter of grace to do it.
But we have to, then otherwise, Your Honor, there was no mechanism for our client to receive the money that the IRS.
No, it was. All you had to do is send it by certified mail. Right? If you send it by certified mail, you're all good, right? Because you fall under 7502C. It's timely. We're all good here.
Well, Your Honor.
I mean, you agree that if you had filed it by certified mail, you would fit into 7502C and you would be timely and you would have your money.
Yes, Your Honor. And I would point, it would be nice if the IRS would tell people that because their own publication, this is what they send to taxpayers, says mail it. There's nothing in here that says you have to mail by certified mail. And in fact, 1993, Judge
You
Ross.
raised like a due process argument on that ground?
Well, Your Honor, so here's the.
I mean, I get it, right? I mean, listen, understanding the IRS code is, gibberish, right? But
right. So they have buried it in the CFR. But what is published for the taxpayer says stick it in the mail. 1993, Judge Ross Anderson in the District of South Carolina looked at this provision, this same language, and said, IRS, you can't rely on this nonsense when the statute just simply said, the publication simply says, stick it in the mail. 1993. In 2011, they enacted this regulation, which says, oh, well, no, but it has to be certified mail. 2020, it's the same language from 22 years ago, or from 27 years ago, when Judge Ross Anderson said, we're going to stop the government because it's not telling the public you got to use certified mail. And Your Honor, their argument is not, as Mr. Willey said, that we didn't file the claim. Their argument is they didn't write it down when they got it. There's no evidence in this record. There's no allegation.
His argument is that they never received it.
Well,
there might not be evidence of that. I get your point, but that's their argument.
That's not in the record. No, Your Honor. The only thing in the record is that they don't have any record of receiving it. This document was not returned by the Postal Service. There was mailing the same day to a different IRS office that they got, Form 843. The only thing in the record is, the only date is July 17, 2017, that the IRS wrote down itself. And consider this, Your Honor. A lot of people sign their return and take it to the mailbox. And so it's, practically speaking, it's mailed the same day it's signed. That's the way I do it. Well, if the IRS takes the tax return, but they've thrown away the envelope, they could plausibly say, well, it was probably mailed the same day it was signed. And under 7502A, the date of mailing is the date of filing. And so they say, okay, so it is plausible that what happened was just that. They opened the envelope, they looked at the date, they didn't look at the postmark, they looked at the date it was signed, they typed into the computer July 17, 2017.
Your point on that is you ought to get to do discovery to find out if you can support that. In your world, that's a theory.
Right.
That you think you've plausibly alleged enough facts to put forward, but you got to do discovery to figure that out.
And we don't have, all we need is some evidence of actual delivery. It doesn't have to be conclusive. This is just motion to dismiss. Get us over the hump. But, Your Honor, I would submit that the IRS's position is if the Postal Service messes up, it's the taxpayer's fault. If the IRS messes up when it's delivered, it's on the taxpayer. And as this court said in Curry,
Unless the taxpayer uses certified mail.
and still has the receipt. Because if the taxpayer paid for certified mail, didn't think anything about it, and lost the receipt, and I don't recall which case it is where they couldn't find the receipt, even though they alleged they had done, you got to have the receipt. And so
You
if
got to
the
have proof in court.
right,
I mean,
so still the IRS loses it. And this court said in 1978 in Curry that the government cannot rely on its own negligence to the disadvantage of a taxpayer. Now that's a prisoner case. But it's the same point. So if the Postal Service and government employees mess up, then the taxpayer suffers. If the IRS employees mess up because they get it, but they don't log it right, or they throw it in the trash, or it gets lost between the mail dock and whoever's supposed to process it, then the taxpayer suffers on that. And so, yes, Your Honor, the only saving grace is that we don't follow what the IRS says in Publication 17.
We follow what Congress says.
We
pick Congress instead of, listen, you got no problem with me there, right? Like, instead of following, the executive branch's sort of description, we'd actually just follow what Congress says.
If you conclude that Congress said in C that there's no more mailbox rule, that the only way to prove it is to have certified mail unless the IRS does its job, then yes, you're right. Your Honor, I say I'm way over my time, so.
You were going to cite some case here that you picked up a piece of paper and said you all said something.
Your Honor, that was reference to the Curry case from 78, where this court said that the government cannot take advantage of its own negligence.
Thank you very much.
Thank you, Your Honors.
Good to have both of you, or all of you here, and we appreciate your good work and your fine arguments. And if we could do so, we'd come down and shake hands with you and tell you that personally, which this court does normally, but we're suspended that practice because of the pandemic. With that said, Madam Clerk, we will adjourn court for the day.